Joining us in the studio is attorney Sahmara Stevenson. Thank you so much for being here.
Well, thank you so much for having me.
All right, the big question, why do people need to have a will when so many people don't have one?
The big question, yes, so many people don't have one. Is it 76% of Americans don't have a will today? And that's a large number. I think it really speaks to the broad misconception about who and when. So who estate planning applies to and when these types of questions need to be answered. The answer is, if you're over the age of 18, estate planning applies to you, and it's time to talk about that.
So for that 76% you said who don't have it, if something bad befalls them and they pass on, what happens to their assets?
Well, when someone passes away without creating a last will and testament, they didn't serve as a testator if they're a man or a testatrix if they're a woman and create a last will and testament, they're said to have died intestate. And the intestacy laws will apply to how things are distributed, taxed, and handled with regards to their assets. So essentially, when you don't make a plan, the state has a plan for you. And in the case of death, it's the intestacy laws in the state where you pass away.
Is that necessarily a bad thing? I mean, are the intestacy laws, if I said that right, unreasonable in some respect?
I don't know if we say bad, good, or bad. It's just more about making sure that we understand what's at stake. The more we know, the more we can control the flow. That's both the flow of the assets in an estate, but the flow of power and control over who's making decisions. You've mentioned end of life, but incapacity is also a part of this conversation, which is where I think people get misled by the term estate planning. Estate implies somehow it has to do with assets or accumulation of wealth. Really, I like people to encourage people to talk about it as life planning. It's part of a conversation that we need to have about how life is going to go, how decisions are going to be made for us in the event that we can't make decisions for ourselves, and how our values are going to be upheld and respected in any circumstance.
How difficult is it for people to sit down with you and make all those decisions about questions that none of us really want to face?
It can be very, very difficult. There can be a lot of apprehension to talking about end of life because superstitions or uncomfortability, maybe just feeling overwhelmed by making those types of decisions. It can be very difficult. So my job as an attorney, or at least I look at my job as an attorney with Stein Sperling, to be able to help people navigate walking through and making those decisions simpler. So biting off smaller portions, thinking about things in terms of shorter periods of time, for example. One of the major decisions that people have to make when they have minor children, for example, is guardianship. Choosing a guardian to look after your minor child in the event that you're not here to do that. Thinking about that in terms of the rest of your life can be, again, overwhelming. But if we take it off into a smaller chunk and just say, what are we okay with for the next 3 years? Who would be okay with for the next 3 years? Because anybody is better than what the state's plan is for you, which is Child Protective Services.
You know, it seems like somewhere on the planet, generally in Hollywood, there's always a big celebrity estate battle going on. Some celebrity has passed away, somebody's contesting it. How often does that happen for normal people?
All the time.
Really?
All the time. If it can happen to celebrities, it can happen to any of us. You know, I like to say people go from grief to greed very quickly. And so making sure that we have plans in place, but also that we're updating those plans. Your estate plan should grow with you over your lifetime. So as circumstances change in your life, as people change in your life, you should be making those changes to your estate plan as well. And a lot of times we see these controversies come into play when people haven't updated something and a long period of time has passed and things have changed. And now we have people left behind who, you know, have some issue with how things have been left.
There's something called a will substitute. What's that?
A will substitute?
Yeah, and I'm thinking in terms of different ways of titling investment accounts or bank accounts, so that it passes without going through the intestacy system.
Sure. So there's avenues, there's People love to avoid probate. I get people in my office who say, Sahmara, I want to avoid probate. I want to create a trust because I want to avoid probate. I love to start there just by saying there's no way to avoid probate except not to die. There's tools we can use.
Sign me up. That sounds great.
There's tools we can do to help sidestep probate or shorten the probate process. One of the ones you mentioned was transfer on death, I think is what you were saying, or setting accounts up so that someone can take immediate control over a bank account or another type of account or asset without having to have the courts get involved. Yes, that is one avenue to go in. I would say as an attorney that it's not the foolproof way to go with regards to planning. And again, there's no right or wrong. Everything is going to be based on an individual need basis for an individual or a family. But what you leave, what I find when people will rely on transfer on death or just having joint accounts is that there is no backup to that backup plan. And so creating an estate plan, or if your goal is to avoid probate or the estate administration process or the courts being involved, using estate planning tools like creating a revocable living trust, for example, which eliminates the court's need to be involved with the actual estate administration or reduces it greatly.
Reminder viewers, if you have a question about wills and trusts and estates, you can send us an email to livequestions@mpt.org. Let's talk about Congress, which likes to change tax laws all the time. They just did it again.
Yeah.
How does that affect your average client, and what happens when state laws don't change at the same time?
Yeah, so the big beautiful bill, which is what's been in the news lately, and if you haven't heard about the inheritance, the change to the exemption inheritance tax at the federal level being to $15 million, which I think is safe to say that there aren't that many people who fall into that category. And I think that the consequence for me as an trust and estates attorney, the consequence for that for me is really trying to make sure I emphasize that estate planning goes beyond tax planning. That might be the goal for some people who are getting involved with creating an estate plan, but there are things that go beyond that when it comes to making a plan. I really encourage clients, when I work with them at Stein Sperling, to begin with the end in mind. What is your end objective? Avoiding taxes might not be what you're trying to do. Maybe it's creating privacy around your assets. Maybe it's creating ease and eliminating the needs for attorney's fees and court costs on the back end for your family as they're trying to settle things after you're gone.
You mentioned that there's special urgency for LGBTQ folks to pay attention to this stuff this year. Why is that?
Well, I think that's looking at, forward thinking towards what there are some concerns about the protections around LGBTQ families, specifically with the respect to gay marriage and whether or not that's something that is going to change at a federal level. I think that really lends itself to a conversation that needs to happen in LGBTQ families about how do we make sure that we are planned for accurately, no matter the change in the law. And also acknowledging that with the change in a federal law is going to create some difficulties with there being fluidity across state lines. So making sure that you're planning with regards to not only where you're living, but what's going on in other states that you might end up having to use your documents in.
Viewer question, what are the benefits, if any, of a Medicaid trust, and how much do they cost to set up? I should ask you that generally about wills, but in terms of Medicaid trusts, what do they do?
So we're talking about Medicaid and Medicare asset planning. So we're talking about, this is a type of planning that looks at making sure that you're going to qualify for Medicaid benefits in the event that you fall ill and need to take advantage of long-term care facility or in-home care, whatever the case may be. And Medicare and Medicaid planning takes into account that the government is going to look back, as it has a 5-year look-back period, into what assets you have in your belongings are what, in order to qualify you for actual Medicaid. And when we get into Medicaid planning, one of the advantages to that is that we're making sure that people are protecting the assets that they have in a timely fashion. So making sure that that 5-year look-back period doesn't create a situation in which they need to spend down the assets that they have that they might be wanting to pass down to the next generation in order to qualify for those benefits.
What does all this cost? And you don't have to give me a specific number, but I know people are going to see ads online for free or very low-cost will preparation services. And thoughts on whether that makes sense in certain circumstances and what it costs to have a professional do a custom approach.
Sure. I mean, at the end of the day, a lot of the times you get what you pay for, right? So if the price sounds too good to be true, you should be questioning that for good reason. It doesn't mean you can't get what you need for a lesser dollar amount. It just means you need to pay attention. So generally speaking, your will, a complete planning is going to be not just a piecemeal document like a will. It's going to be a will, a power of attorney, a medical advance directive, HIPAA, waivers that relate to your medical advance directive, living will. Those documents and a complete planning package like that is going to be somewhere between $1,500 and $2,000. This is going to vary across whether you're working with a large firm, a small firm, exactly what you're looking to get out of the experience. Your trust planning is going to start around $3,500, $4,000 and can range all the way up to $12,000, $15,000 depending on the complexity.
Now, who needs that? Who needs to have a trust?
The complex planning part, or the
just to set up any kind of trust.
To set up any kind of trust. It's a case-by-case basis. I am a real advocate for revocable living trusts. I think they're an amazing tool that helps families with planning, but also help streamline things for the next generation that's coming behind them. They're a great way to keep your personal information out of the court's purview. One thing that people people commonly don't realize is that a last will and testament is public record. It is for your eyes only while you're living and breathing, but once you pass away, in order for an estate administration case to be opened in your name, an original copy of your will needs to be filed with the orphans court, and it becomes a matter of public record. It's out there forever, might matter to you, might not. I used to say people could walk down to the courthouse and look up how you've left things. Now you just get online, click a few buttons, and download it for $2.50. So it's just something to consider. When you create a trust, one of the utilities of a trust is its privacy, and it's not something that the court gets involved with.
Aside from planning to deal with this at the right time, what other big mistakes do people make?
Not having the conversations, right? Not having the family conversations, not involving everybody that they need to in the planning process. So I really encourage people to find a way to be confidently vulnerable when they're talking to family members about this.
Say that again.
Confidently vulnerable.
Okay.
I'm a member of the sandwich generation, right? So I have my little 2 under 2.5 right now, and I got an older mom who I'm caring for, who I do care for. I'm not responsible for. I shouldn't say it like that. However, these conversations we need to have about how we're going to care for each other, or a larger family conversation.
Sahmara, we're going to leave it right there.
Yeah.
Thanks so much for joining us.